in Israel, would the will be considered valid at the time it's making, or is it made valid later in our case scenario?
It's a very good question. I don't think I can give you a definitive answer.
By the way, he's only saying that... Wait a second. Michael's only saying that so that you will hire us later when the situation comes up. I'm sorry. Go ahead, Michael.
In Israel, well, first of all, I think the question really has to be answered by the Ontario court. Naturally, they'll rely on the Israeli laws, but ultimately the Ontario court will have to make the decision. What happens in Israel is that even though the will is validated later, it will be assumed to have been valid retroactively. That is, there's no gap from the time a person dies until the will is validated. If the estate is, even though we don't know exactly what's going to happen to the estate, we don't know if the will be validated. Nevertheless, once it's validated, his estate is passed as of the moment of his death. But I mentioned before that Israeli system here is quite bureaucratic and things take a long time. I would imagine that in the circumstances you described, the Ontario court would probably be ahead of the Israeli court, and you would be in the court in Ontario before the Israeli court has even decided whether or not it's going to validate that will.
Okay. I'd like to end with this, I guess, this practical conclusion. If this matter were to come to me, I would likely suggest that since you need an original will in Israel, your first step would be to get probate in Israel. And thereafter, look for ancillary probate here in Ontario. Thank you. Michael, thank you very much.
Okay, thank you, and enjoy your day. I'll be leaving in a moment.
All right. Bye-bye.
Thank you, Charles and Michael. I'd now like to introduce Archie J. Rabinowitz. Archie is a partner with Fraser Milne. He acts as a counsel on litigious estate and trust matters. He regularly makes applications to court for the appointment or removal of personal representatives and has been involved in numerous court applications to defend the validity of wills. Archie is also involved in matters such as estate claims, breach of trust actions, undue influence claims, interpretation of wills, and the appointment or removal of trustees or committees. He represents parties, trust companies, and government agencies in court on contested passing of counts of personal representatives. He has extensive experience in dealing with the Canada Revenue Agency and voluntary disclosures under the income tax in connection with litigious estates and trusts. Archie also has extensive trial and appellate experience in every level of provincial court, including the Ontario Court of Appeal. He represents clients in a wide variety of industries in general commercial litigation with emphasis on major licensors and franchisors, employment litigation, and defense insurance work with professional negligence, product liability, and as preferred counsel for LawPro. Archie?
Much for the introduction. Good morning, ladies and gentlemen. I was going to suggest to you that I would just come up and read my paper, but with the font size, if anyone can read the paper, you have to be a lot younger than I am, especially the footnotes, so I'm not going to be looking at my paper. In any event, what I am going to be speaking about is rectification, which is all about fixing mistakes in wills. Wills have become much more complex as brilliant estate planners have come up with ideas of how to save probate taxes and deal with assets in different jurisdictions. Charles and David were just talking about a fact scenario with a client who had property in multiple jurisdictions. This is something that's becoming more and more prevalent. And as that's become more and more prevalent, it has led to creative estate planning, and with creative estate planning comes human error. And of course not the brilliant estate planners that we have speaking today, but there are other estate planners who are more human and will inevitably draft something that's got an error, either on its face or sometimes not on its face, and I'll talk about that in a moment. Think back a couple hundred years ago, this concept of a will, a last will and testament. The document itself was sacrosanct. The courts in England treated it like the Holy Grail. You couldn't tinker with it, you couldn't play with it, it was what it was, and a person had testamentary freedom. Some old maxim from England, which is now considered sexist, a man was free to do with his bounty that what he chose, and if he decided to give it to charity and cut the wife and kids out, too bad, too sad. That's of course not the case today. We have all sorts of remedial legislation which says not so fast. Spouse has a right under an election, under I think Section 4 of the Family Law Act, that if the spouse doesn't like what her deceased spouse has done in his or her will, the surviving spouse can say, too bad, I really don't care what was left in the will, I'm going to take an equalization payment if I do better off than that. Others who have been cut out of a will, of course, have other remedies, such as dependence relief. They can say, I've been inadequately provided for under a will, and so I can drive a truck through a will that way. What I'm trying to get at is to say that despite the English tradition that has been in existence for a couple hundred years, that a will was sacrosanct and you really couldn't do anything with it, whether you liked it or not, the opposite is true today. A will, of course, I don't want to discourage people from doing wills, but it doesn't have the same meaning that it did a couple hundred years ago. A will is now a starting point, a negotiating point, unfortunately, in many families. And I'm, God forbid, am I encouraging families to litigate, but inevitably, as my wife says, if everybody got along, I'd have to close real estate deals or do something else, but an honest living. The reality that wills are being drafted with mistakes leads to the question as to, if there is a mistake in a will, what can be done about it? So again, the original traditional jurisprudence said you couldn't do anything about it. You were stuck with it, and too bad, too sad. The more modern approach has been to slowly open the door, especially in Ontario. There's been a slow movement to allow the courts to give them power, and this is really judge-made power. This is not legislative power, so it's the development of the common law, which means you're at the mercy of how far a judge is prepared to go. Some judges were reluctant to start tinkering with wills because when we're talking about rectifying mistakes in wills, the most important person who could tell us whether or not it contained a mistake is not there. The person's dead. So the person's not available to give the evidence as to what he or she intended in the document. So let's then discuss what powers the court has to fix wills. If a mistake is patent, in other words, it's obvious on the face of the document, if I owned 100 King Street West and I left in my will a gift of 200 King Street West, the issue then becomes, after I pass away and the lawyer reads the will out to my anticipating heirs, good news, someone, Mikey, will say, Mikey has been left 200 King Street West, except for one minor problem. Archie never owned 200 King Street West at the date of his death, so what happens? So we have this doctrine called ademption, which is basically failure, which means if I didn't own it at the date of my death, the gift fails, Mikey gets nothing. Comes this new jurisdiction, I won't say new, but recent jurisdiction of the court to say, well, not so fast. That's a pretty harsh result for Mikey. It's obvious that what Archie really intended to do was leave him 100 King Street West. And is it really fair that Mikey get nothing just because somebody made a mistake in the will? Well, the answer is the court may be able to fix it, but someone's got to come forward and say that Archie or Archie's lawyer made a mistake in his will. And unless the lawyer is prepared to, and I guess has the stones to do it and confess that he or she made a drafting error, there may be a problem, because who's going to be able to put evidence before the court to say that it was a mistake? Obviously, I am presumed in my will to only be dealing with assets that I really own. What's the point of me leaving the Empire State Building to Mikey? I never owned the Empire State Building. So a person is presumed, of course, to cover assets in their will that they actually had an interest in, certainly at the date that they drafted the will. So the court does have the power, if it receives appropriate affidavit evidence substantiating the fact that I owned 100 King Street West throughout my lifetime, and of course it was a typo, and usually the professional who prepared the will is good enough to confess and say they made a mistake, and that's where Law Pro, which is the insurers for all of our good lawyers in this province, comes in and hires people like Ian Hull and others, my colleagues, to do repair work and pay for the cleanup, shall we say. Of course, if I have competing beneficiaries, I have a daughter, Sherry, not including my wife in this scenario, she would never fight. But if Sherry took the position and said, no, there was no mistake, he really meant to give her 200 King Street West, and just because Archie didn't own it at the date of his death, the gift fails. It's the doctrine of redemption, and Mikey gets nothing. Of course, Sherry has a motive for doing that because 100 King Street West would then fall into residue, and she's a residual beneficiary, and blah, blah, blah. So you can only imagine what happens when family members are jockeying for financial advantages to take advantage of these errors, and that's what leads to a number of reported cases. Our first speaker, or one of our first speakers and host, Charles Wagner, was involved in a matter. I was involved only on behalf of Law Pro for the good lawyer that made a little mistake. But Charles was counseled successfully in a rectification application where, in my fact situation I gave you, I'm using my kids' names, Sherry and Mikey, but the Sherry in that case actually took the position and said, no, there was no error on the face of the will. That was exactly what the old man intended. In Chuck's case, it was actually more absurd than my fact situation, because the error, the will that got signed by accident, was a draft which didn't even contain a residue clause. It was complete. It was just a complete ridiculous. It was impossible that any human being would have intentionally signed a will that didn't contain a residue clause and other mistakes in it. And it was all because a clerk at the lawyer's office accidentally emailed the wrong version in Word format to the accountant, and the accountant didn't tell the lawyer that the accountant was going to go get the will signed, where the lawyer was waiting for instructions, and actually calls the accountant up weeks later and says, hey, what's going on? I sent this will out, I've left messages for the client. And the accountant says, what are you talking about? I got the will signed a month ago. So the lawyer doesn't realize the wrong version got emailed out, and sort of gets his nose out of joint and says, all right, well, why'd you get it signed? Well, he asked me to come over and get it signed at the nursing home. So the lawyer says, fine. The lawyer doesn't think of phoning the client up and saying, could I see the copy that got signed, or can I get a copy from my file? And wouldn't you know what happens? The wrong will has been signed containing this ridiculous error. And the lawyer sends a bill, gets paid, closes his file. A year later, 2 years later, the gentleman unfortunately passes, and when they read the will, they realize, what the heck is this? This doesn't make any sense. It has English words, but it's completely ridiculous. And of course, everything unravels.